Okay, hi again. We are now in part 4 of our webinar on the legal aspect in organization. So for this part, I'm going to brief you on managerial prerogative. Okay, in Malay, it is prerogative pengurusan. Okay, what is managerial prerogative? Managerial prerogative is a power given to the employer, okay, so that it can manage its organization, okay, without disturbance from the employee. However, in exercising its prerogative, it has to be done in good faith, or we call it bona fide or bona fide in America. Okay, the American pronounce as bona fide. British pronounce as bona fide. Okay, so even though it is the power given to the employer, but it has to be implemented. It has to be done in good faith. So actually, the court did not list what amounts to major prerogative. Okay, but what I have here is based on the cases. Okay, so let's start with the hire. Okay, and in terms of the right to hire and fire. Okay, in terms of the right to hire, as I said in our first part, that the law does not intervene who you want to hire for your company. So you have to know, the latest technique in how to ensure that the candidate is suitable for your company. Okay, so that is, it is totally up to you, up to the company. Okay. Next is promotion. When it comes to promotion, it is again that is also manager prerogative. So it is up to the management to who they would like to be promoted. Okay, but the problem is that if you do not promote a person, if you promote a person without merit, meaning that he's a sloppy employee, he's not a performer, but you promote him or her for other reason. Maybe he or he or he could be your relative. Okay, maybe she is your girlfriend and so forth. Okay, so but nobody can question your authority to promote that person. Okay, but if you were to do this, then you're sending wrong signal to the employees. The other employees who have been working very hard, they are hoping for the promotion, but they did not get it because they are not your family members, they are not your girlfriend, and so forth. Therefore, this person will become demotivated and they will start looking for other jobs. So in long term, it is the company or the organization who is at loss, because if the competent person who's supposed to be promoted, but he was denied the promotion, then he left your company, then you will have to train a new employee. And it takes time for someone new to become familiarized with the new schedule, the new job, and so forth. So when it comes to termination, nowadays, for an employee to terminate an employee, it has to be done for a valid reason. Let's say because the company is closing down, the company is not making profit, and so forth. But if you just terminate a person just because you don't like him or her, or because, again, as I said in the first class, in the first video, unreciprocated love, cinta yang tidak berbalas, therefore that may amount, meaning that you are no longer in good faith. You terminate him or her because of ulterior motive, or because you terminate him or her because he's very active in the trade union. So that amounts to wrongful dismissal. Similarly with transfer, yes, you can transfer your employee anywhere as long as their expertise are needed in the new place. Okay, but if you just transfer him or her so that the union will become less active, then that amounts to mala fide. Okay, so in fact he can challenge you that for constructive dismissal, which I will explain in the next video. And similarly with assignment of tasks. Okay, so at times, when let's say A is a very good employee, whatever task that you give him, he will do it ahead of time compared to B. Okay, so sometimes it's resulted to the situation whereby A is always given so many tasks to do because you know that A would deliver what he's being asked to do, but which resulted to B is given lesser work, lesser tasks. So this is unfair. So meaning that even though it is your prerogative to assign tasks or to allocate the duties, but you have to be fair to your employees. Then so through the power to, though the power to run its organization lies in the hand of the employer, however, as I said earlier on, that such prerogative must be carried out in bona fide, that means in good faith. Okay, next we move on to the current workplace issues. I have listed a few issues. There are tons of issues at workplace, but I have listed the common ones. So dealing with discipline, wrongful dismissal, which is interrelated with manager prerogative. I will explain to you on the rights of probationer and then on OSH and in terms of sexual harassment and the preparation towards aging society and also flexible working arrangement, FWA. Okay, when we talk about how you can end a contract, there are many ways where you can end a contract. You can resign, or you can, employee can resign, or employee can, when you resign, it is out of his own free will, sukarela. But employer can terminate, let's say because of misconduct, because of non-performing, or because you are going to downsize your business. Let's say now let's say your company has, let's say, 500 employees, but now because of economic downturn, you need to downsize. You only need, let's say, 200 employees. So therefore, the other 300 employees are made redundant. Then you are allowed, in the eyes of law, to retrench, but it has to be done according to the legal procedure, which I don't have the time to explain to you in this short video. When it comes to dealing with discipline, you have to know whether it is minor and major. What is minor and major misconduct? It varies according to the industry. Let me share with you that, let's say in a food manufacturing company, it is a big no-no that you're not allowed to eat while performing your duties. That is a major misconduct if in a food manufacturing. And another example is that, let's say a clerk fell asleep once in a while. That might not be major misconduct, but a security guard who is supposed to be awake while on duty, but if he fell to sleep, that may amount to major misconduct. Again, your company should define what amounts to minor and what amounts to major. And if you, let's say normally for minor, normally you will call the employee and you give advice. Normally, the law does not say anything how you should handle this. Now, based on the practice, if it's a minor misconduct, you just give oral warning. Maybe up to 3 times. It depends on the practices in the company. Then only then you will, you put it in writing. Then when it is writing, it is in the file, in the employee's personal file. But for major misconduct, let's say the guard who fall asleep, or let's say if there is any, if the employee commits theft, okay, so therefore you can, okay, you must conduct domestic inquiry or due inquiry. So meaning that you let him know the charges which is made against him, and you give him at least 2 weeks for him to prepare. So meaning that he'll be suspended for 2 weeks with half pay. And then you will call him, okay, for domestic inquiry. And then, okay, the prosecutor for the company, okay, normally HR will, okay, uh, will present the case, and the employee can defend. Okay, so there will be a chairperson. Okay, you must make sure that the chairperson is not someone who has interest in this case. It could be interest here, could be he's not related to neither the prosecuting officer, the PO, or the employee who is being accused of misconduct. Okay, or he cannot be someone who is subordinate than the person who is charged for misconduct, because otherwise he has interest in that post. He will obviously he will make sure that the guy is guilty, so that he can take over the post. So meaning that there is an element of bias here. So that is why you need to observe the rule of natural justice. So the rule of natural justice comes in the form of, okay, the person who is being charged for misconduct must be informed of the charge, why he's being charged for misconduct, and there must not be elements of bias, berat sebelah. Okay, so now the chairman, okay, in the domestic inquiry, okay, let's say the chairman, what is the chairman of the panel role? The chairman of the domestic inquiry, okay, listens to the case, and he can always ask questions should he want to. Then he come up with a decision whether the employee who's been charged, whether he's guilty or not guilty. He's not the one who decide on the punishment. Okay, then after that, okay, the notes of proceedings, you must have the notes of proceeding in the domestic inquiry. And after the decision is made by the chairman, then okay, HR, okay, will make recommendation as to the punishment. And it is advisable for HR to, okay, to find at least 3 years, okay, appraisal for him. Okay, maybe why, okay, there is reason why he commits such misconduct. So it is unfair by just punish him, okay, for the misconduct committed in that particular year. What happened if he was an exemplary employee for the past 3 to 5 years? So you must take that into account as well. Okay, because if he was a good employee before, then maybe it is not justifiable to terminate him, but you can demote him. Demote means turunkan pangkat. Okay, so who will decide? It will be the board of, okay, director who will decide what is the form of punishment, okay, to be given. Okay, then, okay. Okay, what about poor performance? Okay, let's say if someone who's not performing, okay, actually the law says that you must give him chances for him to improve. You cannot simply terminate him, so, okay, there and then. So give him a chance to improve and give a time frame, let's say 6 months from now, and put it in his personnel, in his personnel file, okay? And after 6 months, start review again his performance, okay? And there is also a trend nowadays that that the company, especially the big ones, they conduct due inquiry for non-performers. Okay, meaning that they want to make sure that if there is termination, it is done, okay, legally. Okay, unlawful termination or wrongful termination, okay, meaning that an employee is terminated and there is no justifiable ground given. So meaning that it is done in bad faith, mala fide. So means, okay, at times to the company, they have reason because I hate you, but I hate you is not a justifiable ground. There must be a ground that is connected to it has to be work related, okay? So it cannot be because you terminate him because he's active in trade union, or he's very vocal, okay? So that amounts to mala fide. So an employee who is smart when he feels that he should not be terminated. So actually he has three costs, okay? He has three options, which I will explain later. So these are examples of mala fide, threatening behavior, okay, or victimization, or you give unrealistic target, okay, which is impossible for someone to complete within the time frame given, okay? So for any employee who thinks that he should not be terminated, okay, therefore he can claim for wrongful dismissal. Okay, so actually there are three options for him. The first one, okay, you can go to manpower department. Okay, but under manpower department, they do not have the power to reinstate. Reinstate means pulihkan semula jawatan, ya. They do not have the power to reinstate. They can only determine whether there is sufficient notice or not. If there is no sufficient notice, then they will issue order to the company to pay you the termination notice. So to me, manpower department is not an option, okay, when in the event of wrongful dismissal. Yes, you can go to civil court, but and then you can ask for, okay, normally you go to civil court, okay, under the breach of contract on the part of the employer. Then you can ask for damages, or you can ask, okay, you can ask your, okay, damages for your losses of your loss of income. And you can, let's say, if you have to seek medical treatment, then you can count it in, okay, your trauma and so forth, okay. But it is advisable to hire a lawyer at this stage, okay. But you can, if you know how to the court procedure and you are good in, okay, you know, okay, what to ask, okay, then you can defend yourself, okay. You can, okay, I mean, you don't have to hire a lawyer, but actually, to be honest, it is better for you to hire a lawyer. And this is number 3 is the most common, because number 3, it is still under a Ministry of a Human Resource, but it is very cheap and it is in a way very fast also. Okay, this is what we call as under Section 20. Okay, but there is a time frame. It has to be done within 60 days from the date of termination. Okay, for civil court, okay, the limit is 6 years. Okay, six years is from the date of termination, but for industrial court it is 60 days. Okay, so okay, the case will be heard in the industrial court. Okay, you bring evidence and the employer will also bring evidence, okay, and the court and the industrial court president will decide whether there is wrongful dismissal or not. So if there is wrongful dismissal, okay, meaning that, okay, you should be reinstated in your previous position. Maksudnya, kalau ada berlaku wrongful dismissal, kamu akan dipulihkan semula jawatan kamu. Okay, kamu akan kembali, sepatutnya dikembalikan jawatan kamu. So meaning that therefore you will get back pay. So let's say if the case takes 15 months to settle, so you will get 15 months, okay, back pay. However, on top of this, okay, at times the court may come to a conclusion that it is pointless to send you back to your old position because the relationship between you and your company is no longer amicable. Okay, no longer amicable. Therefore, the court may order reinstatement, okay, indemnity in lieu of reinstatement. Normally in Malaysia, it is based on 1 year service, 1 month salary. So if that person has been working for that company for 10 years and the court said that he's being wrongfully dismissed. On top, let's say he earns, let's say 10K. Under industrial court, there is no wage threshold. Okay, anybody can go as long as you are a workman, meaning that you are not the decision maker for that particular company. That's why we have seen cases whereby general manager or director who was terminated and they go to industrial court, okay, to file for reinstatement. Let's say the salary is 10K. So now the case took 15 months to settle. So he will get 150. But normally the court will deduct if he's been working elsewhere. And the court may further award for indemnity in lieu of reinstatement if the court thinks that the situation between the relationship between the claimant and the company is no longer harmonious. Therefore, let's say he's been working for 10 years. The practice in Malaysia is that 1 year for 1 year. For 1 year, 1 month for 1 year service. So on top of that, 10 months, service. So 10-month compensation. So, he will get roughly about the 300K compensation. Okay, now I'm going to explain on the constructive dismissal because many people do not understand. Okay, they do not even know that that amounts to constructive dismissal. Okay, what is constructive dismissal? It is where an employee leaves his employment as a result of the employer breaching fundamental term of the employment contract, fundamental term of the contract of service, or where the employer displays an intention to no longer be bound by the employment contract. So, in short, the employee quits because of the breach. But the law here that it is dismissal. For example, now let me give an example. Now let's say a director, let's say a senior manager who is given, let's say, a BMW with driver, and this general manager or senior manager, he has his secretary, but out of the blue, when he turned up to work the next day, the CEO or the owner of the company asked him to surrender the keys to his BMW, and the driver is no longer assigned to him, and he does not have his secretary anymore. And for the company still give him a car, but instead of BMW or equivalent to BMW, now the company only gave him Proton Saga. It's not that I am degrading Proton Saga. I used to have one also, but I just want to show to you that how the act of the company to replace the BMW with Proton Saga, it is not of equivalent value. So in these circumstances, the senior manager can treat himself to be dismissed constructively. So he will go for constructive dismissal. But there is no, the employer does not dismiss him verbally or in writing, but the act of the employer as if he is no longer wanted. So that amounts to constructive dismissal. Or when there is a breach of the fundamental term, let's say, let's give you an example here. Now, let's say you are the marketing manager for the whole Malaysia, earning 20K a month, but you're very busy. So the company is very considerate. So now the company, appoints another person. So now you do not control the whole Malaysia anymore. You only control the west coast of Malaysia. And there is another, another marketing manager for east coast of Malaysia. Your salary is not affected. You still earn 20K a month, but your power is now reduced. So in these circumstances, it depends on that person. If that person thinks that, hey, the fundamental term of my employment contract is now been breached because I used to control the whole Malaysia. Now I only control the west part of Malaysia only. So that is, that affects my dignity. Okay, so in these circumstances, constructive dismissal may occur. However, if that person thinks that, okay, fine with me, now I'm very happy, I have less work, I have more time with the family, but my salary remain the same. So there will be no constructive dismissal. That is why constructive dismissal is very technical, because the line between what amounts to constructive dismissal and what does not amount to constructive dismissal, the demarcation or the line is very, very thin. Okay, so the situation differs based on the case, okay, from case by case. Okay, so here, okay, meaning that if you want to change the terms of your contract, it has to be done um, by consensus, okay, from both employee and employee. But when let's say the changes in the job title, it was done by the employer only, so it may amount to constructive dismissal. Okay. So, however, if a person would like to, okay, consider that he is being constructively dismissed, so he has to leave the company and inform the employer immediately that I treat myself to be constructively dismissed. If he were to delay from leaving the company, then the most likelihood that later on he will be barred from claiming that he is constructively dismissed. Okay, so how long? Okay, you should wait. Actually, the court does not say, but in my opinion, 1 month is considered one. I think 1 week or 2 week is reasonable. More than that is no longer reasonable. Okay, so if you delay, therefore you cannot claim constructive dismissal anymore. Okay, so the burden of proof is upon the employee to prove that he has been constructively dismissed. Okay, so he must notify employer of his stance and consider himself constructively dismissed before leaving. Okay, then if you claim that you are being constructively dismissed, then you can go to, okay, either a civil suit or you can go to industrial court. Okay, so normally people will go to industrial court, but for your information, those in government sector, you cannot go to industrial court. You have to go to civil court. So what amounts to constructive dismissal? I've already explained a breach of the term, the fundamental term, and it is so serious, okay, that warrant the employee to leave at once. Okay, if the employee did not delay in terminating the breach. However, if he delay in leaving the company, that amounts to condonation. Okay, and the condonation is a waiver for reinstatement. Condonation means something like you akur, you redha, you terima. So one waiver ni was something yang menghalang, ya. So such a condonation is a waiver for reinstatement action, okay, in the industrial court. So in the case of Janico Associate and Lilian Terrera de Costa, what happened in this case was that Lilian Terrera de Costa claimed that she was, okay, sexually harassed, okay, by his managing director. Okay, so she claimed that she is wrongful. Okay, she claimed for constructive dismissal. Okay, however, okay. Okay, however, the court, okay, industrial court accepted, okay, and industrial court agreed with that she was constructively dismissed, okay, because, okay, there is a repudiatory breach when the managing director harassed her, meaning that, okay, an employer must make sure that the safety of the employee, but when the employer himself did such an act, so that amounts to repudiatory breach of the contract. So the industrial court agreed with Lilian. However, when the case went to the High Court, the High Court's, okay, disagree with the industrial court's decision. Why? Because Lilian took 1 month, okay, to file a claim. Remember, in that case, okay, you have 60 days. So when Lillian took 1 month, technically it's still fine. But the court the judges in the High Court think that 1 month is too long, okay, and there might be possibility that she could have concocted the evidence. Concocted tu maksudnya menambah-nambah. Mereka cerita concocted. Because of that, and then furthermore, the court could see that the statement that she gave contradicting with one another, because maybe, okay, but the reason why she took a month, because in 1990s, okay, sexual harassment was not really discussed. It was swept under the carpet, okay, so we don't know what to do, okay, but the court rejected, okay, the industrial court's decision. Okay, in the case of Informatic and Josh Vasky, okay, it was the change in the job function and the title of the post. So it amounts to constructive dismissal. And in Kianju, okay, Nurul Shafika was transferred. So she claimed that she has been constructively dismissed when she is transferred to another branch. But actually, the court said that transfer is prerogative of the employer as long as it is done in good faith. And the court did not see any mala fide with the transfer. So meaning that Nurul Shafika's claim of constructive dismissal was rejected. Okay, now let's look at the rights of probationer. Okay, probationer, orang dalam percubaan. Okay, seseorang yang dalam percubaan. Okay, so okay. An employee under probation, okay, enjoys similar rights as those who have been confirmed. Why? Okay, because that is decided in the case of Kalia Abbas. Why? Because in the Employment Act or in the Sabah and Sarawak Labour Ordinance, okay, the act, the statutes, they do not differentiate the confirmed or non-confirmed staff, because the statutes only mention employee. It does not say that, oh, this is applicable to confirm, this is not applicable to probationer. There is no, okay, what the statutes, okay, Employment Act, Sabah Labour Ordinance and Sarawak Labour Ordinance only address employee. However, I noted that there are misconceptions on this, okay. Many companies say, oh, she's just a probationer, we can terminate him, okay, there and then, okay, that is wrong, okay. And why do we need probationary period? Okay, normally how long? Okay, the law does not dictate how long a probationary period should be. It could be 3 months or it could be 6 months. It depends on the organization. Okay, so why do we need probationary period? Okay, to ensure that the employee has the ability to perform the task given. Okay, and to determine the level of employee's capability. So we have to, okay, to make sure that the employee is able and capable of doing the task. Okay, so if he's non-performance, therefore you can give him time to improve. Then if he fails to improve, then you can end the contract of service. Okay, the rights of probationary employee is clearly discussed in Pakir Jalil. So upon the expiry of the probationary period, employer must confirm, okay, if employer, let's say, not happy with his performance, therefore inform the employee that he has not performing satisfactorily, therefore the probation period is further extended to a certain time. Okay, and what if the employer does not make any attempt to inform? So in these circumstances, okay, you have to check the contract of service, and you have to refer to the employer's conduct. But according to the case of Cassie Matthews, an employee is deemed not confirmed if still in the employment with the employer, despite the fact that the probationary period has expired. So based on Casey Matthews and also in the case of V. Subramaniam, if the probationary period has ended and you did not receive any news, whether you've been confirmed or not, then you are still a probationer. Okay. Okay, in the case of Perry Perumal and Abdul Majid, okay, Perry Perumal is a clerk. Okay, he is on 3 months probation. So in his contract of employment, it states that he's entitled to annual leave once he's been confirmed. And okay, so after he finished his probationary period, the employee did not confirm him. Okay, and however, the employer allow him to go, okay, to take the annual leave. So now the question is that whether he is now a confirmed staff. Okay, what happened was that, okay, when the probationary period ends, okay, he did not receive any news from them. He continued working and he wanted to take leave. So he applied to HR. HR allowed him to be, okay, to go on leave. Later on, then they realized that he's not confirmed yet. So, okay, the company asked him to repay the amount of, okay, the money which is equivalent to the days that he was on leave. So then, but he argued that he is now deemed dianggap, he is now deemed a confirmed staff. Otherwise, HR would not give him, okay, the annual leave. So now can you see or not? HR, this is a situation whereby HR is negligent. Okay, so here the High Court decided that employee was confirmed in employment despite not being expressly confirmed, as meaning that even though he does not receive any letter, neither employer says that you are confirmed. Okay, but the act of granting leave amounts to amounts him to be treated as a confirmed staff. Okay, so the company is not satisfied. The company took the case to the Court of Appeal. However, in this Court of Appeal, affirm, meaning that bersetuju, affirm with the High Court's decision. So the important factor in this decision is the existence of the element of granting the right of a permanent employee to the probationer. The court said that why HR grant him the annual leave. Okay, so once you grant him the annual leave, meaning that you are treating him similarly as if he is a confirmed staff. So that is why, the company lost in this case. Okay, so a person who is in the probationary period enjoys similar rights as the confirmed staff. That is decided in the case of Khalid Abbas. Okay, so this is misconception. Employer may terminate without notice. Okay, employer is not bound to give any reason. Employer, okay, the probationer, so in these circumstances, okay, if a probationer is terminated without reason, therefore the probationer can file representation under Section 20 as well. Okay, he can claim that he is wrongfully dismissed. So this is in the case of Adrian Thomas de Costa versus Times Academy. Okay, Adrian Thomas is an automotive instructor and he was placed on 6 months probation. However, he was dismissed after 3 months on the ground that he was not able to teach his classes satisfactorily. Okay, this is Times Academy is a private college. Okay, so the students complained to the principal that they did not understand what Adrian Thomas was trying to teach. Okay, so in private academy, okay, the students are treated as king. They will listen to the students. Okay, so he was dismissed. So Adrian is a smart guy. Adrian claimed that he was wrongfully dismissed and he took his case under Section 20, okay, and he claimed for wrongful dismissal. Okay, in the trial, okay, in dalam perbicaraan ya, in the industrial courts trial, all witnesses, agree that Adrian Thomas had problems in communicating with his students, and he lacked essential knowledge. But okay, the court, okay, in these circumstances, okay, the court, okay, said that even though the court could see from the evidence okay, or the testimonies given by the witnesses that Adrian is not a competent person to teach, but okay, the college, okay, the academy did not produce any documentary evidence whether Adrian had been informed of his weaknesses, whether Adrian had been given chances for him to improve. Because of that, the courts, okay, agreed that Adrian was wrongfully dismissed. Okay, and he is entitled to compensation in lieu of reinstatement. So now, if at the end of the expiry term, you either confirm the probationer, or if you're not happy with him, then you extend the probationer. If neither confirm nor extend, therefore, the probationer deemed not confirm. Okay, next we go to the occupational safety and health. Okay, this is my PhD topic. Okay, so as we all know that most people spend at least 8 hours in a day in a workplace. Therefore, okay, our well-being is very important. Okay, so the business owners, okay, is responsible to ensure the safety and health of the employees, okay, or any members, okay, or the public with whom it comes into contact. Okay, so in these circumstances, okay, the need to manage safety and health as effectively possible, okay, is in the interest of the business, employees, and society at large. Therefore, it is important to integrate the management practices or principles with the legal requirements so that okay, the safety and health of the employees at workplace is upheld. Okay, so that is why you need to have a risk assessment, okay, and so forth. Okay, so now when you talk about safety, okay, and health, there are three components. Okay, safety, okay, normally it deals with the injuries at workplace, okay, or accidents at workplace. Okay, normally, okay, the construction, okay, there are many accidents involving death in construction sector, whereas for manufacturing, okay, the accidents at manufacturing that causes um, permanent disability is very high in manufacturing companies. And health. Okay, previously people don't talk about health. Okay, when you talk about safety, they will only concentrate on the safety. And that is one of the reasons why my PhD is in safety instead of health or welfare. Because for safety, there are tons of materials, reading materials, unlike health. Okay, so health, but recently people start talking about health because okay, it seems that in the workplace, mental health issues are on the rise. Employees became depressed, anxiety, and so forth. Okay, so that is why, let's say in Sabah, okay, we have came across an employee shot an employer because he was terminated from his job. Okay, and there is another situation whereby the salary was paid quite late. Okay, instead of going to labor department, the employee, okay, was not happy, shot the employer. And there is another situation. Okay, this happened in a welding company. Okay, so out of the blue, one of the employees slaughtered his colleague. And it turned out that the perpetrator was mentally unstable. Okay, so that is why, and I believe this is closely related to your area because you are in psychology faculty, in the faculty of psychology. So you should always go for okay, seek further knowledge when it comes to the latest development in terms of mental health issues and so forth. And welfare. Okay, when you talk about welfare, why we need to ensure that the welfare of the employee is taken care of so that employees are happy at workplace. If they are happy at workplace, they are excited to come to work. So if they are excited to come to work, there will be less absenteeism. Therefore, productivity will increase. Okay, so you will have normally welfare. Okay, normally I noted that every organization now you have, okay, either canteen or pantry. Okay, so that is where you mingle with one another regardless of their post. Okay, and you have family days. Okay, then you have birthday celebrations. Okay, and you also have fun day whatsoever. So, okay, and you also means many organization provides, let's say, um prayer room for the Muslims. Okay, so this, okay, just to ensure that employees are happy at workplace. Okay, so now this is an example of safety and health issues. So let's say when it comes to safety, you have to look at, okay, whether the tendency of physical violence and so forth. Okay, welfare, you talk about perks and benefits, you talk facilities at the office, whether there is filtered water or whether there is, okay, like in my previous company that I imagine, yeah, that was 20 years ago, we have fridge in our pantry, we have oven, we have, okay, we chip in money, and also the company will buy, like Milo and so forth, okay, on monthly basis. Okay, as why, so that we will keep, okay, the harmonious relationship with, okay, in the workplace. And when it comes to health, apart from mental health, okay, you also have economic issues, whether the, okay, what is economic? I think you know what is economic. It means that, okay, in what way, okay, the tools that we use for work is suitable, okay, okay, to be used by us, it suits our physical. Okay, let's say I am a tall person, so I must use a desk that suits my height. Let's say A is a petite lady, so she cannot, okay, she cannot use the table that I use because she's very petite. Okay, so she will not be comfortable. Okay, so this, and also, okay, you will have, let's say, common issue now is CTS, carpal tunnel syndrome. Okay, when you, or musculoskeletal disorder. Okay, so let's say for me, because I do not know how to type properly, because so if I were to do, okay, repeat, okay, the work, if I were to type without stopping, okay, for hours and hours, it might, okay, in long term, I might be suffering for CTS. Okay, and it caused me backache and so forth. Okay, so then I have to go to the clinic, and my company or UMS pays for my medical bill and medication. Okay, so this is cost. Okay, so now I'm going to explain the important features of OSHA 1994. So when it comes to safety and health, actually there are two main acts in Malaysia: Factories and Machineries 1969, okay, and OSHA 1994. But for today's purposes, I will only explain OSHA 1994 briefly. Okay, when we compare FMA, Factory and Machinery Act, and OSHA, okay, Factory Machinery Act is very prescriptive, and it's also very thick. It's very because it tends to regulate everything. Okay, but under OSHA 1994, the underlying principle is based on self-regulation, meaning that the government does not dictate how you should do that. It is up to the company, and the company must discuss with the employees, okay, what should be done, okay, how they should go about this. So that is self-regulation. So because okay, manufacturing company differs from construction company, so you cannot have one law that fits all. So that is why the government leave it to the employer and employee to decide what is the best practices for their company. And okay, under section 15, okay, provides for, so far as practicable. Okay, so meaning that the employer's duty is only so far as practicable. It does not mean that whenever there is accident occur at workplace, employer will be liable. So it depends on whether employer had taken steps, okay, to reduce the accident or not, whether the employer had done something or not. So that is why the term here is, okay, so far as practicable. Okay, so when you talk about so far as practicable, you have to look at how often it occur. Okay, whether it is anticipated, and you have to look at the cost as well. Okay, whether it is costly or not to eliminate. Okay, so what is the most cheapest way, okay, to reduce the incident? Okay, and what is the employee's duty? To obey, okay, the employer, and not to endanger the colleague. Okay, and under OSHA 1994, okay, every company that has more than 5 employees, the companies must have safety policy. So what is safety policy? It is, okay, an undertaking, okay, it is an undertaking that, okay, that the company will make sure that the employees are safe at a workplace. Okay, and for the companies that have more than 40 employees, they must have safety committee, and the safety committee must meet at least once in a 3 months time. And the safety committee consists of the representative from the management and also from the employees. So they will sit down and discuss, okay, in the past 3 months, okay, is there any accident occurred, how we can reduce that, or if we do have new machinery, okay, what is the best way, okay, and so forth. Okay, or during the COVID-19, so you will discuss, okay, what are the SOP for the employees and so forth. Okay, and NADAPOD, okay, notification of accident, dangerous occurrence, and occupational poisoning and occupational disease. So when there is an accident or dangerous occurrence or any poisoning or any occupational disease, so therefore, okay, employees must inform the employer, okay, within the time frame given. Okay, and the employer must notify DOSH, Department of Safety and Health. Okay. Okay, so we are done with that. Okay, so now let's go to sexual harassment. Okay, so sexual harassment, okay. Um, Hang on a second, I need to add. Okay. Let me continue again. Okay, for sexual harassment, okay, a survey done by WAO, majority of Malaysian women surveyed, okay, have experienced some form of a sexual harassment. Okay, 62% out of 1,010 female. Huh? So that's quite high. So what is the effect of sexual harassment, okay, upon the victims? Let's say in the case of Muhammad Rizwan Abdul Razak and Asma Haji Muhammad Noor, Asma, okay, was examined, okay, by psychiatrists, and she was diagnosed with major depression, which was caused by the harassment committed by Muhammad Rizwan. Even though she was transferred to another unit, okay, but she could not bear the emotional stress. Therefore, to the one extent, she resigned from the organization. Okay, so the effect upon the harasser will be punished, and also the reputation, okay, he will be punished and also affect his reputation. What about the secondary victim? Let's say those who are, let's say, the victim's friends, okay, so they will not feel unsafe as well, okay, so they're not comfortable with what's going on. And what about the organizational effect? Okay, so and the society. So if the trend is, I mean, of the sexual harassment is not curb. Okay, curb means dihentikan. Therefore, it will affect our society. Okay, people do not want to go to work. Okay, and then people will. Okay, so you will be prejudiced upon others and so forth. Okay, so what is the definition? Okay, based on the code of practice on prevention of eradication of sexual harassment at workplace. This is a Malaysian code. Yeah, it says that any unwanted conduct of sexual nature, having the effect verbal, non-verbal, visual, psychological, and physical harassment. Okay, so it can be verbal, it can be non-verbal, it can be visual, psychological, or physical. So it is unwanted conduct. Okay, so unwanted conduct by the perpetrator, by the harasser. Okay, so okay. So, that might, on reasonable ground, be perceived by the recipient as placing condition of sexual nature on her or his employment. Okay, out of the conduct, so the recipient may think that, oh, if I didn't do this, it will affect my job. Okay, or that might, on reasonable ground, be perceived by the recipient as an offense or humiliation or threat to his or her well-being. Okay, so for example, let's say body shaming. Okay, so there are in the UK, it has been decided that it amounts to sexual harassment. Okay, or when you commented on how she dressed and so forth, so it amounts to sexual harassment. But when you talk about sexual harassment, it takes two to tango. If the other person does not feel anything, then there is no sexual harassment. Okay, but I suggest that you stop. I mean, you must not make vulgar jokes, dirty jokes at the office and so forth. So who are normally the potential harassers and victims? Okay, the potential doers, meaning that the harassers are, and the victims are normally is between the employer, the boss and employee, superiors. You could be your senior executive and you are junior executive, subordinates, among colleagues or clients against employee. Okay, your client. In the context of UMS, is between the staff, either academic or non-academic, against colleague or subordinates, against, staff, whether they are academic or non-academic, against students, and among students. So what does workplace entail? So workplace here includes at the place of work during or outside working hours, at work-related social functions, work assignments, and so forth. So this is considered as workplace. So what is the governing law? Actually, okay, that we have protection under our federal constitution, Article 5, Article 8, and Article 8.8 sub 1 and 8 sub 2, and under penal code, which is commonly used. If you but for penal code, when you report your case to the police will do the investigation, then it will become the if if there is a case, the AGC will charge the harasser, and then it will be tried in the criminal court. So if the harasser is found guilty, then the harasser will be punished accordingly. In underemployment statutes, you have section 14. Remember that is under misconduct, or you can claim that you are being constructively dismissed because you are no longer safe at workplace, as what happened in the case of Lillian. But you have to do it. You have to file your case earlier, because Lillian lost the case because she filed the case 1 month after the incident, and also section 15 1E under OSHA. And for the statutory bodies like UMS, we have a separate act. And there is a new, not necessary, not really new, but this is introduced this is the outcome of the case of Muhammad Rizwan and Asma. So any person who thinks that he or she is sexually harassed, therefore she can file a civil suit under tort. against the perpetrator, as what Asmah did. Okay, that is under civil law. So what amounts to sexual harassment? You can see here, dipeluk, dicium, and so I don't have the English version. So, okay. So this is a type of harassment. Okay, verbal, when you say offensive or suggestive remarks, jokes, okay, and okay, and non-verbal, okay, with the act of leering, okay, ogling, or the way you lick your lips, okay, so it's very very sexy and so forth, okay, or the way you eat your banana is very provocative, okay, so that amounts to non-verbal or gestures, okay. Visual, when you show photographic, okay, materials, or you send, okay, pornographic materials via okay, WhatsApp or Telegram and so forth, or letters, okay. Psychological, when you repeated unwanted social invitation, let's say the harasser keep on inviting, okay, the victim for dinner and so forth, okay. And physical, when there is bodily touch, okay. So are we doing enough? Okay, I don't think so. Okay, so there are many people who do not know what is sexual harassment. So what is employer's duty? Employer's duty is, okay, to determine whether there is a misconduct, okay, and determine whether that amounts to dismissal. Okay, what is the standard of proof required? Standard of proof is just on the balance of probabilities. Okay, you just ignore if you do not understand this. Okay, what are the, so now I have a few cases that I would like to share with you. In the case of Janico, okay, she lost the case. Why? Because she took a month to file the case. So, and there is a conflict, there is conflicting testimony as well. Okay, so that is why you need to, okay, the victim need to record, okay, need to record either in writing or, okay, when it happened, okay, you write it down, or you put it in your laptop or something, or if possible, let's say you turn on your telephone, okay, and record, okay, the act, okay, because sexual harassment normally it is not done openly, it is done, okay, in secretly, okay, out of the sight of others. In the case of Vasudevan Atherley and Freescale, the court held that the claimant's one-off action of physically putting his hand on the waist of the complainant, okay, the complainant did not consent to the action, so that amounts to a serious offense. So it does not matter whether it is only, you only did it, okay, for one time or for the first time, okay. So the court held that sexual harassment exists. In the case of Loganathan Maniam, okay, the word sayang, okay, so that amounts to sexual harassment, okay. And in the case of Chen Bing Kui, okay, so the claimant reached out, okay, the claimant, okay, Chang Bikwe, okay, he was being terminated, okay, because the complainant, who is a Muslim girl, complained to the company that that Chen Benghui tried to hold his hand, okay, and touch her elbow and so forth, okay. So so Chan Benghui was terminated, so she is not happy. So he went to industrial court, and the case went to the High Court, and the High Court agreed that, okay, there was no necessity for him to touch the complainant. So because of that, okay, it amounts to sexual harassment, okay. So now these are okay, cases, okay, that decided cases, okay, related to sexual harassment. In the case of Ahmad Zalani, okay, it is through verbal, whereby, okay, the harasser asks, okay, the complainant, okay, kalau awak mau malam ini dengan suami awak bagi ke, that amounts to sexual harassment verbally. In the case of Berjaya Redang, it is in the form of gesture. The harasser, who is a sous chef, okay, unzip his trousers in the presence of the victim. Okay, the victim is a Christian apprentice, and touch and grab his buttocks, okay. So this is between same sex, yeah. Okay, so that amounts to sexual harassment. In the case of electronics, a harasser, this is physical. Harasser touched the victim's private parts. So this is also same-sex harassment. In the case of Chan Park Lin, visual and psychological, the harasser kept ringing his customer, to invite her for lunch, and constantly harassing her by sending cards and so forth. And in the case of Sintat, psychological, the harasser, who is a senior manager, invited her to spend the night together, commenting on her dress and so forth, and even threatened her that she will be put in cold storage if she were to ignore his advances. So that amounts to sexual harassment. Okay, the leading case, as I said to you, Muhammad Rizwan Abdul Razak and Asmah Muhammad Noor. So, okay, in this case, Muhammad Rizwan, verbally, harass her, on so many occasions, and she complained to the superior, and here, then Muhammad Rizwan sued Asma under defamation. Saman malu lah. But Asma Muhammad Noor fought back by suing Muhammad Rizwan for sexual harassment, and she won. So that's why I said this is another avenue, a new door open to Malaysian, to file for civil suit. Okay, now let's go to the aging society. Okay, um, I think wait, let me check. Is this the new one on? Okay, okay. The declining, declining fertility rates, and rising life expectancy. So, most countries have rising expectancy, meaning that, we live longer, and therefore it, leads to aging population. Okay, the trend is very common in the developed countries like in Japan, in United Kingdom, but now the trend is prevalent in Malaysia as well. And the SOM, had already projected that Malaysia will, there will be 5.8 million of those who are 60 years and above by 2030. So therefore, we are going towards aging society by 2030, and by 2044, 40% of the population is expected to be above 65. Therefore, we will be known as an aged society, and by 2056, Malaysia will be super aged society, just like what Japan, the situation in Japan, with over 20% of its population under age and above the age of 65. So the new challenges for Malaysia in terms of employment, income security, and aged care. So if we live longer, and then, if you're going to have more, increased number of those 60 and above, therefore, there must be retirement schemes and social policies, that cater for their needs or cater for their aging population. And also there must be publicly financed aged care, meaning that, like, it's not home. Home is where the okay those who they are being treated because they cannot take care of themselves anymore. There is home for disabled person, or those who can take care, those very old, they cannot take care of themselves. But we are talking about able body, but they would like to stay in retirement home, for instance. It's very common in developed countries, but in Malaysia, it's still very new. That's why, okay, and it's very, very scarce. I mean, it's very limited, okay? Especially for that caters for the Muslim needs, the needs of the Muslim retiree and so forth, okay? So that is why it is urged that, um, okay, the publicly financed, okay, I mean more, okay, more care center is developed, okay, and because if you were to go to private, okay, it's very costly, okay, so not all of us can afford to go to the private care, okay, or private retirement home. However, okay, we must have a specific law to regulate the aged care facilities, because we do not want, let's say, what are the duties of the carers or the social workers? What, okay, are they being trained, and so, are they being licensed or whatsoever? Okay, so there must be proper regulation. We do not want something bad happen, okay, only then we start to react. Okay, we would like to go for preventive action. Okay, so, and also improve the quality standards of aged care homes, okay, and also the awareness of legal duties of the social workers and the carers. Okay, then what about, okay, how we can, okay, the way forward in dealing with aging society? So it is, okay, we can encourage the adoption of age management strategies by the companies, meaning that companies should cater, okay, if you are going to employ those who are above 60, so what are the kind of tasks that is suitable for them? And perhaps the government could offer incentive for the companies who employ those who are 60 and above. Okay, and also regulatory frameworks to facilitate part-time and flexible employment for older workers. So, okay, in developed countries, older workers, if they work, they normally work on part-time basis. So, are we prepared? Do we have that in place? Okay, and also increasing coverage and adequacy of social insurance schemes. Okay, so these are the way forward, okay, in facing or in dealing with the aging society. Last but not least, let's go to the flexible working arrangement. This is also my research, okay. um okay, this is my research. Okay, I've just completed this research, okay. So when I embark my research on flexible working arrangement, at that time, that was, we are in the first MCO. Okay, so at that time, okay, people are not sure about FWA, how you should go about it and so forth. Okay, and in our Employment Act, there is nothing that provides for how we should go about, okay, flexible working arrangement. Okay, so however, okay, I have written articles and I've presented, okay, in a few conferences, both in Malaysia and also at international level. But of course, it was done, okay, through online platform. Okay, I propose that government should have a specific policy on a flexible working arrangement. Okay, and we can emulate, okay, what's uh the UK and Australian, the law in the UK and Australia. Okay, so these are the examples of, okay, flexible working arrangement, the FWAs. Okay, so now, okay, uh, and finally, okay, with the new amendment of Employment Act, okay, actually the bill means rang undang-undang. Bila belum diluluskan, it is known as bill, rang. Okay, the law which has not been passed is known as bill. Undang-undang yang belum diluluskan dipanggil sebagai rang undang-undang. It was first tabled in December 2021. It was passed by Dewan Rakyat. Then, okay, however, okay, it was Dewan Rakyat, okay, the amendment, okay, slight amendment was made that the maternity leave is, okay, is increased to 90 days. Initially, it was 90 days in December 2000. In the bill, the first, when it was tabled for first reading, it was only 90 days. Okay, and the paternity leave for 3 days. But when it is discussed at the Dewan Rakyat, okay, so they agreed that the maternity leave should be increased to 90 days and the paternity leave is increased to 7 days. And it is approved by the Dewan Negara on the 30th March, and it was given royal assent on the April 26th, and it was gazetted on May 1st, okay, and it will be enforced in 1st of September, on 1st of September. So the amended Employment Act, okay, provide for FWA, okay, however, meaning that, okay, employee may apply for, okay, to an employer for WAs, okay, however, okay, okay, within 60 days, employer must reply whether they agree or they reject or they approve the application. Okay, it has to be done within 60 days. However, okay, if the application is refused, the ground of refusal must be provided. Okay, so at least, to me, that, I mean, it's still a long way. Okay, it is not as the law pertaining to FWA is not comprehensive as what United Kingdom or Australia has, but at least something for a start. And I would also like, okay, the government to have, okay, in the Employment Act, the right to disconnect. Because when we work at home, sometimes the employers contacted us at odd hours. So we should put a stop to that. Okay, so that is the right to disconnect. The right to disconnect actually is relatively quite new. It was first introduced in France in the year 2017. But now it's been followed in by Belgium, Portugal, okay, a few countries already that come up with a policy on the rules to on the right to disconnect. I hope in a few years' time we have that kind of policy as well. Okay, now we come to the end. Okay, in conclusion, it is important, okay, to understand the terms and conditions contained in a contract of service so that we will not be manipulated by the unscrupulous employers. Or if you are the employer, so at least, okay, you will not exploit your employee. Therefore, okay, and the aggrieved party, okay, you know now where to go should you are being, okay, being, let's say you're being victimized and so forth. Okay, so with that, I thank you. Okay, so what we did today, okay, we have gone through the what amounts to major prerogative and also the current issues in the workplace. Okay, and as I said earlier on, those current issues are not comprehensive, meaning that I just chose, okay, the few common ones only. So with that, I thank you.